Welcome, everybody. I'm Mary Boney Dennison, the Commissioner for Trademarks from the U.S. Patent and Trademark Office, and we have a fabulous panel here for you today. We are really excited to hear all our speakers on the post-mortem right of publicity, and I'm going to introduce them in alphabetical order. So, we start with Kareem Abdul-Jabbar, the greatest basketball player in history, as everyone knows. When he retired from the NBA after playing a record 20 seasons, as well as setting the records for points scored, games played, minutes played, blocked shots, and defensive rebounds. He was also a record 6-time NBA Most Valuable Player, a record 19-time NBA All-Star, a 15-time All-NBA selection, and an 11-time NBA All-Defensive Team member. Wow. Don't know how you can even remember all that. But since retiring from the NBA, he's been active as an education advocate, writer of social commentary, novels, history books. He's written 15 books, including his most recent New York Times bestsellers, Coach Wooden and Me, Our 50-Year Friendship on and Off the Court, and Becoming Kareem, Growing Up on and Off the Court. Mr. Abdul-Jabbar also produced a documentary adaptation of On the Shoulders of Giants, which won an NAACP award. And of particular interest to this audience of IP lawyers is his book entitled What Color is My World? The Lost History of African American Inventors. And if that weren't enough, in October he has a novel coming out called Mycroft and Sherlock. So he has been quite busy. And in 2016, President Obama awarded him the Presidential Medal of Freedom, the country's highest honor for civilians. He also is an award-winning columnist for The Hollywood Reporter and The Guardian. Along with his writing, he's a highly sought-after public speaker. So thank you for joining us today. We are also really lucky to have his business manager, Deb Morales, on the panel. Ms. Morales is a successful businesswoman who balances her busy careers as a CEO, an award-winning movie producer, and business manager for Kareem Abdul-Jabbar. As founder and CEO of iConomy Multimedia and Entertainment, Ms. Morales has been helping professional athletes go from success to significance by creating a plan to ensure financial stability while they pursue their post-playing dreams. She has also produced 2 highly acclaimed documentaries, On the Shoulders of Giants and Kareem, Minority of One. As Kareem's business manager, she has helped him realize his dream of becoming a successful writer of novels, history books, political commentary, and screenplays. She's currently writing a book herself about the challenges of being a business manager called The Accidental Manager. Please join me in welcoming Deborah. On the legal side, we're really lucky to have 2 distinguished experts in this area. We have Jennifer Rothman and Priya Royal. Jennifer Rothman is a professor of law at Loyola Law School in LA, and she's an elected member of the American Law Institute and an affiliated fellow at Yale Law School's Information Society Project. She's nationally recognized for her scholarship on intellectual property and constitutional law, and her website, Rothman's Roadmap to the Right of Publicity, is the go-to place for right of publicity questions and news. Her latest book, The Right of Publicity, Privacy Reimagined for the Public World, was published this year by Harvard University Press. She received her AB from Princeton University and an MFA from the University of Southern California School of Cinematic Arts. And she also used to work in the film industry before attending law school at UCLA, where she graduated first in her class. She clerked at the Ninth Circuit, was an entertainment and intellectual property litigator at IRL in Manila, and then she went on to become a law professor. So please join me in welcoming Professor Rothman. And last but certainly not least, Priya Royal is the tax law editor in the Estate, Gift, and Trust Group at Bloomberg B&A. She was formerly an estate tax attorney at the Internal Revenue Service, where she examined high and ultra-high net worth estates, and also worked on training course materials for incoming estate tax attorneys. She has a JD and an LLM in taxation from Villanova University School of Law, and she's been a panelist on a number of webinars and seminars over the years, most recently addressing the 2017 tax reform. She has also been in private practice in trusts and estates and tax law, representing a variety of clients from New York to DC for over a decade. In addition to tax law, she has also represented clients on trademark and copyright issues, especially as they relate to estate planning and valuation. And she is admitted to practice in 5 states. It's amazing. So without further ado, let's welcome Priya. And I'm going to ask Professor Rothman to kick us off. Thank you all.
I think I might be the shortest person on this panel, so excuse me for adjusting the mic. Thank you for that introduction and for inviting me to share my expertise with you this morning and to be part of this incredible event on trademark law, which is near and dear to my heart. It's actually the first subject that I taught when I first became a law professor. We have a short time together for an enormously complex issue or set of issues, and we're only going to scratch the surface of them here today. So my goal is to set the stage for the discussion that follows and for Ms. Royal's comments more specifically about tax law, and to provide some guidance for all of you as attorneys, as managers, and as agents, and most importantly for the very individuals whose identities may be at issue in these sorts of cases. So I'm going to focus on 2 primary topics today. The first is the overlapping set of legal entitlements that apply to the dead, which are not just the right of publicity. And in fact, there's a lot of confusion because they're often collapsed. And the second topic I'm going to focus on is more about the right of publicity, which people know the least about, and talk about some of the challenges for having post-mortem, after-death rights in the identity of a deceased person, and they vary quite widely from state to state. So first, as a preliminary matter, I want to consider the question posed by the session itself. Who owns you when you are dead? Right? And we're not talking about dead bodies here. There's some very interesting cases about who owns dead bodies, wonderful lawsuits. Not the topic of today. We're also not going to be talking about the tangible property of the dead, right? Things like cars, houses, boats, memorabilia. We're not talking about those. So we're going to focus on intangible property and what happens to it after a person, particularly a famous person or celebrity, dies. And so this is also sometimes called the intellectual property, and this includes a variety of rights I'll be talking about. Sometimes the right of publicity is thought of as an intellectual property right, though I think that's a mischaracterization of that interest. So again, our focus here is going to be on these intangible rights in a deceased person, and specifically in their name, likeness, voice, and other indicia of identity. This is not a single right at issue, but a multiplicity of rights that intersect, and teasing them apart is crucial in litigation, in estate planning, in dealing with the growing IRS efforts to tax high-value celebrity estates, and also in the context of pre-death, or inter vivos, right, if we want to go all Latin on it, right, inter vivos transfers of rights. So we need to sort of tease these apart, and that's the first topic for today, is these overlapping legal claims. And I'll start with a basic proposition, which is who owns you after you die has a lot to do with who owns you while you're alive. So that should be the starting point for any evaluation. And then you have to tease apart what are the legal claims at stake in a particular estate. And those include copyrights, which, as you most in this room know, protects original works of expression in a fixed form. So if a person's image or voice is captured in a photograph, a movie, a sound recording, right, those are sometimes thought of as right of publicity related as well, but they're actually also covered by copyright law. And so copyright law is something that survives death. It lasts for 70 years after the lifetime of the author. And in the context of works for hire, which will also frequently be involved in a high-end estate, it lasts 95 years after publication, or 120 years from the time of creation. 95 years from publication, 120 years from creation. So often the person whose voice or image is captured in a copyrighted work is not the owner of the copyright, and that raises some complex issues related to whether the copyright is going to overcome any right of publicity claim after death. But it also is sometimes true that the particular individual owns the rights to the copyright and can assert those rights, or their estate can after death. Second type of right we're dealing with are those of trademarks. And so when we're talking about someone who's famous, they may have a number of trademarks that protect their likeness and name if they're using it in conjunction with products or services, including entertainment services or writing services. And these can survive death as long as the estate or businesses or licensees continue to sell products or services using those same marks with the person's likeness, a particular version of the likeness, and the person's name or related names. And trademarks can last forever, so that's another consideration after death. There's a third category of rights that are sometimes often forgotten in this context, which is there's a whole umbrella of unfair competition laws, including under the Federal Lanham Act and consumer protection laws, varying from state to state, in which an estate could file false endorsement or false advertising claims even after the death of a person, because there might be a suggestion of sponsorship or endorsement by the estate. And finally, the claim that we're going to spend the rest of the time, or most of the time, talking about is the right of publicity. The right of publicity is often misunderstood as an intellectual property right akin to copyright law that's separated from the right of privacy in the 1950s. These are all myths about the right of publicity that I debunk in my latest book that was mentioned on the right of publicity, and I also delve into some more of the issues that I'm talking about today. So if you want to learn more, that would be a place, but those are some myths that I bust there, but I want to make sure that we're all on a level playing field talking about the right of publicity without reading the book in advance. And just broadly speaking, the right of publicity is a state law. It varies widely from state to state. It provides a right to stop others from using your name, likeness, and sometimes other indicia of one's identity without permission, usually for the defendant's advantage. Not always for a commercial advantage. Some of you who have practiced in the area may think that it's limited to commercial speech. It's not in most states, and it's not even always limited to for-profit uses. So there are many variations from state to state, and for our purposes today, not every state has an independent right of publicity, separate from its right of privacy, and not every state has a post-mortem right of publicity. Not every state has a right that survives death. So this varies also widely from state to state, which is one of the reasons out of frustration I started this website in which you can click on a state and find out what the laws are. So I'll talk a little bit more about this in a few minutes, but one of the things you have to tease out is there even a post-mortem right of publicity? So I said the first topic we're going to talk about is overlapping rights. So I want to use the Michael Jackson estate litigation with the IRS to highlight these overlapping rights. So this is the Schedule F form submitted by the Jackson estate, and then Ms. Royal is going to talk in more depth about some of the tax issues, but I'm going to sort of use this to highlight this overlapping issue. So when they filed the form, they had a single item, image and likeness. Image and likeness valued at $2,000 of Michael Jackson, which is absurd, right? That was like waving a red flag in front of the IRS. Come and get us. And the IRS said, no, that's over $400 million at least in Michael Jackson's name and likeness. And we can talk more about this later. But what I want to highlight is that image and likeness was collapsed into a single line rather than being teased out. Image and likeness of Michael Jackson in copyrighted works, photographs, music videos, etc., trademark rights. And then there's the separate question of whether false endorsement, false advertising potential claims or potential right of publicity claims should even be part of the property of the estate. That is something that should be contested. The Jackson estate failed to contest the inclusion of the right of publicity or false endorsement or false advertising in the estate. So that is this Jackson litigation is going to set a precedent. The IRS is using it to be more aggressive in taxing postmortem rights of publicity. But I just want to remind everyone, no one challenged the inclusion of the right of publicity in the estate. That's still something that can be challenged and litigated. And I also want to highlight that they collapsed all of those different property rights, which all should have been separated, just in a single box of image and likeness, which has caused having talked to some of those involved in that litigation, has caused a great deal of confusion by the judge as well as the experts in trying to value this property. So I'm just highlighting those things to show how they overlap, and you need to disaggregate them. And as we think about this, though, I want to focus in on the right of publicity. This is what people, I think, in the room probably know the least about, but I wanted to start by reminding you not to forget about trademarks, copyrights, and related state claims. So one of the biggest challenges, however, is just figuring out post-mortem rights of publicity, and they don't exist in every state. And I'm going to highlight 6 challenges posed by a post-mortem right of publicity, an after-death right in your name, likeness, voice, or other indicia of identity. So first, there's just the variability of state laws. So as I said, not every state even has a post-mortem right of publicity. Some only provide rights to the living. Some have post-mortem rights that only apply to soldiers. And if you want to know why, you can ask me later. But some limit it to soldiers. Some limit it to personalities, people with commercially valuable identities who've been selling products or investing a lot of time and money in making themselves commercially valuable. Some let anyone have a postmortem claim. Some limit claims to those who died domiciled in a particular state. Some open their doors, like Washington State, to all comers. There's a wide range of duration in the postmortem rights. Some provide a 10-year period, some 25, some 30, some 40, some 70, some forever. Some require registration, some don't. Some have specific designated heirs to which it's limited, some don't. So as you can see, one of the basic challenges is just figuring out what law would apply to the particular person you're dealing with. This also raises significant valuation questions for taxation purposes and otherwise. Second challenge I want to highlight is the potential danger of forced commercialization. So as the IRS becomes more aggressive in enforcing a state tax inclusion of postmortem rights of publicity, there's a concern that people who don't, the survivors of a famous person who don't want to commercialize their loved one, will be forced to do so simply to pay off the estate tax burden. Right now, Michael Jackson's estate is heavily commercializing Michael Jackson's estate. They do so regardless of the estate tax situation. But that's not true for every person. Some people don't want to be commercialized after death, and their heirs don't want to commercialize them either. But because of the way the tax works, they will be taxed as part of the estate tax if the right of publicity is included at its highest and best value, at a commercialized value, even if that's not what the person wants to do. This was very concerning to Robin Williams, who developed a very elaborate trust plan to try to avoid that outcome for his family. And so he vested his name and likeness rights and his right of publicity in a nonprofit through the trust, and barred the nonprofit from commercializing in any way his name, likeness, voice, or identity for 25 years after death. Now, I'll mention, not only am I not giving you specific legal advice, but this trust has not been challenged yet, so it's not clear that it will be valid, but it is the primary example I know of someone trying to deal with this potential forced commercialization problem. And of course, that forced commercialization problem could be solved other ways, through legal reform or, altering how the IRS is behaving currently. And of course, getting rid of the estate tax, which could happen any day. All right, so a third potential problem is not having an estate plan at all when you die in a state that has a postmortem right, or maybe that doesn't have one. I call this the Prince problem, right? So Prince is a high-value deceased celebrity who died without a will, didn't think he was going to die, didn't make a plan. So there's several challenges to this. I'll just highlight at the outset, Minnesota doesn't have a postmortem right of publicity. And there was a rush in the aftermath of his death to try to get Minnesota to pass one. And then when I and some others highlighted the estate tax problem and the danger of forced commercialization and valuation, all of a sudden all the support for that bill was removed and it was pulled from the Minnesota legislature because of tax concerns in particular. But even putting those to the side, there's the problem of who's going to inherit and who should get the value of this money of our dead person. Now, just again, reminding her of the overlapping rights. So this is not about copyrights or trademarks, which will vest in whoever the heirs were, but specifically about the rights of publicity, and we want to provide this additional value, and to whom. So in this case, there were a lot of estranged sort of relatives of Prince who now wind up owning him after death. It's not clear that that's what Prince would have liked at all, as compared to his fans, who he's a big supporter of, and allowing them to perhaps have in memoriam posters and other things to celebrate in him. And there was also, for a while, a fight by someone who was incarcerated and claimed to be a child of his, claiming that he should have rights. So we might want to think about that if we tease apart postmortem rights, or maybe what we want them to look like, who should get them and when, and particularly if there's no will involved. And this ties up with a fourth potential concern, which is the question of who profits from postmortem rights and potential abuse, particularly of the elderly. I don't know if some of you read the recent New Yorker piece or saw John Oliver talking about guardianship with the elderly and some abuse in which older people are sort of stripped of their assets and lose control. This could happen to older celebrities as well, who may not have family watching out for them, or even the family themselves, as we see in the instance of Stan Lee, may be taking advantage. And there could be a transfer of postmortem rights of publicity while the person is living. And so this may shift wealth to a company, for example, that's wholly unrelated at the expense of others, and they may do things that the person might not like. I give an example in the book, but also there's one I circle here, Betty Page, who's one of the top 10 dead celebrities. And she's actually, you probably know a lot more about her now that she's dead, because she's owned by CMG, a corporation that owns more dead people than anyone else, and they've turned her into big business. We might ask, do we want all that wealth shifted not to close heirs of a survivor, but to just an unrelated corporation that's making hundreds of millions of dollars off dead people, away from the public being able to comment on people? And I'll also mention that Betty Page, who became very religious later in life, sort of rejected some of the more sexual imagery around her, and yet this company that owns her is now selling a sex toy line, the Betty Page sex toy line. It probably wouldn't have been something she would have chosen if asked. And this sort of shift about transferability leads us to the last two things that I'll just highlight. One is about transferability for the living. So privacy rights don't transfer to after death. But if we make the right of publicity transferable at death, in most states that brings along with it transferability during the lifetime, which could lead to some abuse of the least powerful. So if we think of aspiring actors, singers, musicians, they may assign their rights forever in their name, likeness, voice to managers, to agents, to reality shows. Parents may assign forever the rights of their children. And in the context, for example, of student athletes, a condition for playing in the NCAA is to sign a very lengthy contract, and also to get your scholarship money, and the NCAA claims to therefore own the student's rights of publicity forever. The standard student athlete agreement, according to the NCAA, transferred to it all rights in perpetuity to the commercial use of student athletes' images, including after they graduate. And we can play out the implications of that, but I don't have time now, but I just want to flag that for you as people call for more expansive post-mortem rights. We should be careful not to harm the living, who may lose control over their own identities. And if you think this only applies to celebrities, you might want to think about those terms of service on Facebook and what they could do to your own rights in your name and likeness. And finally, I'll just leave us with some thoughts about some potential free speech issues, and this really affects valuation too, because all of these rights are limited by the First Amendment, and when we think about the breadth of some of these rights from a legislative point of view, we also need to take these under consideration. So I'll just highlight a few examples of this. Martin Luther King's estate, Martin Luther King Jr.'s estate, has been very litigious over his name and likeness rights. The bust in the center is something that the Martin Luther King Jr. estate sued over its sale in multiple copies, and prevailed in shutting that down. So people could not buy these and have them in their homes to honor Martin Luther King Jr. On the left is the memorial here to Martin Luther King Jr. and the federal government. I know there are a lot of federal employees in the room. I don't know if people know this. The federal government paid $800,000 to the estate to get permission to make that statue. I don't think they had to pay, but that's the sort of thing, honoring someone, and Elvis's estate also sued over an honoring statue in Tennessee. On the right is a plaque that Rosa Parks' estate sued over that was sold by Target to celebrate civil rights. That lawsuit was ultimately rejected for reasons that I don't have time to go into. But these are the sorts of things that we might lose out on if we have an overexpansive postmortem right, but that you also need to think about in terms of valuation as well as uses in movies and books. And so I'm almost done, and we'll turn things over. And I'll just to think about in the discussion, why should we have postmortem rights? We might want to think in particular about the dignitary interests of the survivors. Obviously, the deceased no longer have a need to be paid, and they may have dignity in a broad sense, but in the law, we generally don't respect or make laws based on the dignity of people who are no longer living. But also, there's lots of ways in which other laws, trademarks, copyright, and unfair competition, might apply after death. So I know others are going to talk after me, and Ms. Royale, I will turn it over to you to talk in more depth about tax, and I will try to get your...
Good morning, everyone. So as you can guess, I'm a tax attorney. I read the code for fun. It's also the bedtime story for my daughters, unfortunately. Just to get an idea of what sort of audience I'm speaking to, how many of you here are IP practitioners? Are any of you tax practitioners or have a tax background or a CPA by any chance in here? So we're going to have fun. Okay. So Jennifer did an excellent overview of the general issues that arise in estate planning, estate administration. I'm a former IRS estate tax attorney. I did planning. I continue to do planning, which essentially means the things I draft to protect my clients' interests, I basically look at them and say, this is going to get picked up for audit, and I can't do anything about it, but I can win. So that's sort of what I'm throwing out, some terms that you should consider when you speak to your clients, to your employer, if you're in corporate counsel, for considerations on things that an estate planning attorney should address. And one of the reasons I'm excited that Mr. Jabbar is part of our panel here is that he sort of represents the conglomerate of issues and different types of IP rights that could be tax issues. It's sort of what would be the value of him in his authorship rights versus his basketball legend rights versus his speaker rights versus his journalist, reporter, sort of editorial rights. I mean, the list could go on, and from an IP standpoint, what you would think would be what you'd tack on for a license agreement is not necessarily what is going to be the case on a taxing end, especially when you're dealing with post-mortem rights. So the right of publicity, essentially, in a nutshell, is the commercial value of a person's name, likeness, or image. And where there's commercial value, there's an asset attached to it. Where there's an asset, there's an estate. Where there's an estate, there's a tax. So anything that can be taxed will be taxed. I always joke and say, you always start with Section 61 of the Internal Revenue Code, which says all items are included in gross income unless excluded otherwise, which means never ask the question, will this be taxed? Always ask the question, will this not be taxed? And how do we make it that way? The way you can sort of minimize the tax and not make it taxed at a certain time or in a certain way or a certain amount is obviously to transfer the right, which is why we're sort of touching on the transfer of the right of publicity. The survival of the right of publicity, I know Professor Rothman touched on state law, which is sort of an evolving landscape. Some states allow rights of publicity to survive, some don't. There's case law that basically, in New York, there were no post-mortem rights of publicity, which means it was free for all. The Marilyn Monroe estate is actually one good example of that, which I'll get to in a second. One of the things that most literature out there and most of the material has not touched on is actually dual citizenship and estate tax on the right of publicity. Take, for example, we're going to pretend kill off celebrities now. Charlize Theron from South Africa. Assuming she has dual citizenship or dual residency, what laws apply? Right now, the WTO does not govern the right of publicity. They do not manage it, they do not limit it, they do not define it. So how do you define it? What is the value? She may have international acclaim. She may have publicity rights. She may, Aeon Flux, for anybody who watched it, that could be her image. That could be used in various things. So that is, in terms of evolving landscape, let's just say there is a lot of work and possibly a lot of employment opportunities at the IRS for estate tax attorneys, if somebody wants to get into the minutiae of this. And for estate planning attorneys, this is a great area, especially if you have an IP background or you've dealt with IP in specifically trademarks, copyrights, and sometimes patent ideas, the broad concepts come into defining this right of publicity. So these are sort of like touch point examples of how the law has progressed in the tax arena. Right of publicity, as Professor Rothman could probably tell you, has been around for a very, very long time, several decades. The tax issues of the right of publicity, as of today, we actually have no idea how they're going to get taxed. Well, we have no idea to the extent I can disclose how they're going to get taxed. So, so the tax history is, we sort of look at the estate of Marilyn Monroe as establishing right of publicity for tax purposes because it was an issue of domicile, which sort of goes back to the dual citizenship idea. We're taking it beyond states to other countries because we live in a global digital age. And so in the estate of Marilyn Monroe, she passed away in 1962. And essentially her heirs, 50 years later, wanted to tack on a right of publicity to the things that were being used, her image, her likeness, in 2012, because they thought it a commercial value. And if you think about it from the IRS perspective, this is exactly what they're taxing. If you think it's unfair that they tax somebody's name, image, and likeness, somebody's making money on this. So why shouldn't there be a tax? That's one perspective. On the other hand, you are who you are, how dare you tax me as a person, right? So, that, in that case, it was basically judicial estoppel was what kicked in. For tax purposes, New York had more favorable tax laws and protection laws at the time she passed away in 2012. They wanted to switch that because they wanted the protection of the California laws. The court said, you don't get to eat your cake and have it too. I mean, it's just, you just can't have it both ways. And then I call it the escalation point, estate of Whitney Houston, which would be a mystery to most people out there because the IRS settled with the estate of Whitney Houston. She, on paper, died impoverished. She owed, I believe, $4 million, and her estate was only $3 million. At the end of the day, they agreed on a $2 million value. And the way this works is, estate gets audited. Everything in the estate is everything that the taxpayer had full dominion and control over at the time of death. Standard of valuation is date of death. There are no statutes, regulations, or Internal Revenue Manual guidelines, as far as I know, which dictate that the time of death is to the precise second and not the second after. And the reason this is important is because if you take a celebrity or any sort of, Mr. Jabbar would actually be a good example. I'm sorry, Mr. Jabbar, but we're talking about estates, so I don't mean to talk about it, the very future. You have sort of established yourself as this person who's for social justice, as an author predominantly, and moved away from your role and your emblem as a basketball legend. I mean, that is sort of the first part of your career. After you pass away, the basketball legend aspect of it is going to get commercialized. That is a given. But does the value of your persona as a basketball legend now carry a greater value because 1 second after you passed away, you are now worth more on that piece than as an author. Because it is very likely that the commercial value of your profile as an author is less than the commercial value of your basketball history. So this becomes an issue for valuation purposes because tax is taxed at 40% of the asset in the estate. So what are you putting in that estate? So then the estate of Michael Jackson, the very famous case where the estate reported a $2,100 value, the IRS says $500 million. It is, as an estate planning attorney, it is not a red flag. The estate of Michael Jackson is the red flag. So there are several estates of extremely huge public figures that have been put at thousands of dollars, hundreds of thousands of dollars, and they're billionaires. And the reason is estate planning. With Michael Jackson, he did not actually die with $2,000. He had excellent estate planning attorneys who literally pulled $1 billion of his assets out of his control on paper. He died wealthy. The IRS was, I'm sure, not too happy about that, and they wanted to find some way to get a piece of it. So they found something else and said, your right of publicity is worth $500 million. But there was an issue about whether he would have any value in his persona, because there were various contentions. He was sort of not in the greatest view publicly at the time he died. The IRS would take the perspective that that allocates a discount to his value, not eliminate it, because there is a risk of litigation that proves that his value was less than what they deem it to be, and it's going back to the time of death. There is one case involving stock restriction rights, which literally went into the time of death. It is a corporate business asset case, and that may get pulled by a brilliant estate tax attorney into a situation like this, but it is a very hard argument because, as I said, no statutes, no regulations, date of death is your valuation. So date of death, on the date of death, at the time he died, IRS says he was worth $500 million. We are looking to see what is going to come out of this case, because this is sort of what you didn't see is when Professor Rothman put up the Schedule F of 866A. 866A is a form that the IRS uses to make assessments. That is not the estate tax return. The estate tax return for estate of Michael Jackson, my guess would be was probably somewhere between 7 to 20 boxes, because they contain valuations with details in them. That is required. It is not a complete 706 without valuation. So those questions we're waiting to get answered will probably be answered in the court dicta. And if they weren't there, they were probably presented at trial, and they will show up in the court dicta. I mean, it's there somewhere. And we're basically putting valuation experts against valuation experts. What is the value? And how much time does the IRS really want to spend on this? That's what it comes down to. The future estate of Prince, man died without a will. Big mistake. Not selling services, but big mistake. Not only were his regular assets not protected, his right of publicity, the value, is unknown. The uphill battle in an estate tax audit, which is guaranteed, essentially, I would say, for all intents and purposes, it'll probably encompass several hundreds of thousands of dollars in legal fees. That is a cost of not doing a 5-figure estate plan. Because you're going to go through, and the estate tax statutory period is 3 years, or if you take a situation like the Michael Jackson estate where they reported the value of the right of publicity at $2,000, there is a clause in the statute and the regs for gross undervaluation, which essentially means that the asset wasn't reported, or if it wasn't reported specifically enough, as the instructions require, the estate remains open indefinitely. So this is why expert, seasoned estate tax attorneys who understand the implications, who understand celebrities, who understand public figures, who understand what IP means, what the right of publicity means, is crucial, and they have to be consulted. The first time you as an IP attorney draft a licensing agreement where you're giving a company name rights to one of your clients, you should be talking to a tax attorney. Because maybe that name right shouldn't be going as a direct person to the entity or that person. Maybe it should be sheltered through a trust. Maybe it should be sheltered through a business entity, because we can split rights. We can create remainder interests. We can create income interest so that the person who owns these rights can have control over them while they're alive, but still not have value in them when they die. These are complicated, extremely, it's like, I would say, intense, very multi-layered sort of planning. And the nebulous part is, we don't know if these are going to be blessed by the IRS. But we have an argument, and at the end of the day, when you create a trust and you put it in there and you create remainder interest, you have an argument where you can at least negotiate it. And negotiating means maybe you can get less than 50% of what the IRS claims the value is. If you have nothing, what is your argument? You never took anything out of the estate. So with the IRS, most people don't know this, estate and gift tax audits, there are about a little over 250 attorneys in the country who work for the IRS as estate tax attorneys. They have fun going out to the middle of the country to look at every single estate and gift tax return that has ever been filed. There is no return that does not pass the purview of an attorney. You will only hear about it when it is selected for audit. So if you think that putting your client's write-up publicity at $100 million is going to escape audit, be advised, that is not the case. Because you have a potential for dispute on a valuation issue that is most likely going to go for a full audit and an exam. But you can cut that time when you have reliable valuation reports in the record, great experts who are collaborating with you, a team of tax attorneys, CPAs, IP attorneys, who can go into every aspect of this basically off the top of their head. And that'll cut down the cost of examination from hundreds of thousands of dollars significantly. And any client out there is going to enjoy having to not have legal fees after they pass away, so their beneficiaries get even less. Theoretically, it's a deduction of the estate tax return for the legal fees, but remember, at a 40% tax, you still lose 60%. So, NACVA is the National Association of Certified Valuation Analysts. They have developed specific business valuation methodologies. They're highly respected by the IRS. If a valuation analyst, business valuation, IP analyst, anybody has a NACVA certification, they know the standards to follow, they know the order to put it in, they know the format, they know that they need to address all three approaches to valuation, which I will touch on. And if those things are missing, it becomes an insufficient valuation report, which is more easily challenged. So I recommend looking for some sort of certification and background for these valuation analysts. And most attorneys, I went through, so while at the IRS, we were put through the training for NACVA certification, so I can actually do a strategic valuation. The slides here, you're going to get a copy of it. So it looks like we will run out of time quickly. So I just want to sort of touch on these points so that you can always follow up with me with questions and I can go through them. Essentially, you have an appeals process. There's a higher chance of negotiating at the appeals process, and the tax court is your decision maker eventually. I mean, and then the costs we just touched on. I think we can go back to what Professor Rothman considered this. Discounting is something I touched on again. Risk is discounting. On the reverse side, if somebody is worth the value of because they did good protecting of their public rights, the IRS has the ability to tack on a premium. So it goes both ways. You can actually be more than what you thought your licensing rights were for your client. Income, cost, and market approaches are three approaches. The most widely used as in this evolving field is actually a combination of the income and the market approach, which basically factors in future streams of income and comparables, although I do not know who you would use as a comparable for, say, Mr. Jabbar, because he is sort of the unique case, which goes back to valuation of unique art and other nebulous items. The IRS has experts for everything you can imagine. There have been valuations of show dogs. So there is nothing that they do not have the resources for. And this is, again, splitting the right of valuation. I spoke about trusts, moving it. There are a couple of cases. The Trump-type conundrum is, at what point does free speech end? At what point does his rights as a celebrity, which has value, which includes the estate tack on? That's interesting. I'll probably have a couple of articles on that upcoming, so you can view more on that. There's obviously more restricted transfers. Again, IP attorneys, you're familiar with that. It's very similar to the business idea of licensing. I'm speeding through this because I just got a note that there was just probably less than 1 minute at this point. Charitable option, there's a deduction on the estate tax return for the charity. The role of the estate planner flips. The estate planner wants to create the highest value for the right of publicity when you're putting it into a charity, because that's the highest deduction. It also increases the basis of the property, so when it transfers, because when you transfer it in a CRAT or a CRUT where remainder interest may go to non-charitable beneficiaries, you have increased basis in some assets, so capital gains are lower. As I said, this is sort of, I'm sure, goes over the head of most people who have absolutely no interest in tax law because boring numbers in the Internal Revenue Code. So, but either these are things that you can mention to clients, to your employer, to your companies, and it sort of gives them an idea there are other things beyond the scope of just licensing rights, what happens today, royalties, and things of that nature. And I can go through those, you can, as I said, you can follow up with questions. And here are some references for a general review and an article that one of my colleagues published. But, and if we have any time, would we have any questions or comments from anybody else on the panel?
Morning, everyone. My question is, how does someone with some level of fame know that they need to do estate planning around their right of publicity? I'm 71 years old and now trying to deal with this type of planning for my family and my survivors, and I'm just learning about it. So how do they figure out, who to go to and what questions to ask?
We are sort of in the session of what should your lawyer know to be a good lawyer. And I think the ethics panel may want to address this, whether it would be an ethics issue if you don't advise your client about things they should be considering that are not necessarily specifically within the scope of the engagement. And a good business manager should be aware that these issues exist so that they can vet the attorney, because invariably for famous people, the business manager essentially manages who's hired, who's not hired. And understanding these issues, at least on a very broad level, is critical to that. So I would say get good people so they know what they should know. And it never hurts to sort of keep abreast of what is happening in the news, because the estate of Michael Jackson is in the news. And you sort of say, what is this? Does this apply to me? Always ask, is this my issue?
I think that people need to start, it's not about age, you mentioned your age, but I think anyone who has a high commercial value identity needs to make a plan, because no one knows when they're gonna die, so it doesn't really matter how old you are, it matters if you have a large enough value estate that you need to make a plan.
Well, let me add that everybody should have a basic estate plan. As soon as you have let's say a reality show star walk into your room and say, I want to be in this project where I'm going to get paid $500 for 6 episodes, you need to tell them, we need to start thinking about where we're going to put those $500. Because it is likely that tomorrow that $500 may be $500 million. So you have to start at the very basic level and you build on estate planning. You start low, so your fees are low, and then you keep building more and more trust instruments, and it's a lifelong process.
Now, I'm Kareem's business manager, and I've been doing this for about 15 years as his manager, and I consider myself one of more the savvy managers out there. I'm very aware of issues, but I didn't know about this. until just a few months ago, and we have lots of famous friends, and we've been talking to all of them, and they don't know about it. It seems that they think this Michael Jackson case is an anomaly. So while I'm not a lawyer, what is my responsibility to inform my client of these type of issues?
From my perspective as a business manager, you are competing with other business managers, and your duty is to enable your client to be completely aware and protect them entirely. So in terms of responsibility, you should be aware of what legal issues may arise and what essentially you need the information you need to know to vet a tax attorney and an IP attorney. You need to know, so how much is my client's right of publicity worth? And they sort of give you this glazed look, we have a problem. I mean,
I think there are different issues. One is a legal issue, which is do business managers have a legal liability to know about the right of publicity? And I'm going to put that to the side. But there's another issue, which is should a business manager know about the right of publicity and the issues related to it? Absolutely. I mean, I think that's important, but it's not just about the managers. The people who most need to know about this are the actual individuals, and not just the wealthy and famous, but everyone. Because I don't know if people notice, but some of the strategies that Ms. Royal suggested and that people with high value estates are enacting are potentially jeopardizing those who have less valuable estates, as well as the living. So, for example, in New York, there was a recent push to pass a post-mortem right of publicity, and there's a very small subsection of individuals across the country for whom a post-mortem right of publicity matters, that the IRS will care about, that will transfer. But by setting it up in a certain way, what it's going to do is that the sort of less powerful athletes and the individuals will be harmed by some of the transfers, and there won't be protection for them. So I just want I want to make sure that people see the sort of the bigger picture. But I think business managers should absolutely know, as well as the individuals involved, about the right of publicity and associated rights.
Are the right of publicity laws protected differently by each state? And how does that affect people that might have roots in various states or homes? How's that determined?
I'll take the first part, and then maybe you can
Yeah,
take the
because
second
I
part
can do it
of that. So the states vary widely. So only about half of the states provide any post-mortem right of publicity. So the other half don't have it, or we don't know whether they have it or not. And of those, as I mentioned initially,
Sorry, when you say that some of them supply it and some of them don't, does that mean that if there's no right of publicity in the state, then there's no estate tax, or is that still?
See, that's the second part of the question. And so this is not a simple, this is not a simple answer, because the IRS doesn't know, and as you probably realize from this conversation, they want to try to get the most tax. They're going to value it at a very high rate. So they're going to say, well, we don't know that there's a postmortem right in your state, but since we don't know, let's presume there is. And let's presume that it looks like this other state's right of publicity, and then we'll value it as if it's fully commercialized, and there's never a First Amendment defense and never a copyright preemption defense, and you get all the money all the time, and that's what we're going to tax you on. So, that's the IRS position. As a matter of state law, that's not right, and so it's hard to know exactly but that is an area of litigation, that will eventually be sorted out. People are going to challenge, hey, look, I died in a state there doesn't, or the estate will say, I died in a state, there's no post-mortem right of publicity. I died in New York, I died in Minnesota, there's no post-mortem right of publicity, so you shouldn't value it.
Dr. Rothman, if you die in New York and you're Marilyn Monroe, and your estate is being monetized by a company like CMG, and the family is not getting the money because they died in a state where their right of publicity is not protected,
So it's more complicated than that. So Marilyn, yeah, let
was
me
just
just
gonna-
answer
okay,
that
go
part,
ahead.
and then I'll tag in. So Marilyn Monroe is complicated because Marilyn Monroe tried to avoid paying California taxes, her estate, and by doing so, they said, oh no, she was a resident of New York when she died, so we don't have to pay those taxes in California, which are higher than those in New York. Then later, when her estate wanted post-mortem rights, they said, oh no, she died in she died in California because we have those post-mortem rights. And the court said, no, you can't change where she died. She's dead. You picked one, you're stuck with it. So that's right. That's a slightly different issue. And so I want to reiterate 2 points that I made. One, the right of publicity, whether Marilyn Monroe's estate has a right of publicity after death or not, doesn't change that her estate still can enforce false endorsement and false advertising claims if anyone's claiming to have official Marilyn Monroe merchandise. It doesn't change any ownership or enforcement of trademarks and copyrights that the estate holds. So there's still a lot of money related to Marilyn Monroe's name and likeness separate from whether New York has a postmortem right of publicity. And then I'll just add to that the additional piece that some states open their doors to all comers. So Washington State, for example, and Hawaii, if you sell Marilyn Monroe merchandise there, under current law from the Ninth Circuit, and it hasn't gone all the way up to the Supreme Court, the Marilyn Monroe estate can enforce those rights in those states because you don't have to have died domiciled in those states to enforce your rights as to products sold in those states. Yeah, thank you.
So just a caveat to something Professor Rothman said, the tax person. For tax purposes, you can pick where you die. So that's sort of what she was touching on with domicile.
You can't change it.
You can't change it. You can pick where you die. And you can sort of, the definition is a little bit fluid, so you can sort of say your domicile is in one place and not the other if it's advantageous and you have enough contacts and things like that. I'm going to that right now. The other thing is you can also pick where your rights of publicity get valued and where they, so to speak, die to have an afterlife, because that's where planning comes in. When you pick and choose and you put it into entities, let's say Nevada has no tax on corporate. Maybe some parts of those right of publicity, I'm sure Mr. Jabbar is quite fond of his name, but if he wants to use, if he never applied to use Lou Aslandor, for example, maybe he could put that in a Nevada trust somewhere and never use it, but then he could monetize on it because other people want to use it. So he would give up control, or he could retain control, have an income interest, and then we would give up control when he dies, and that's a different type of trust. So I've essentially probably confounded the audience, but I'm sorry.
I just want to add. I just want to reiterate something because I think if I read the tea leaves right, what's going to happen over the next 25 years is that high-value individuals like Mr. Abdul-Jabbar and others are going to create companies and vest their rights of publicity in them as a tax strategy to avoid things. But the problem is that the door will then close. And so the next Kareem Abdul-Jabbar will sign an NCAA contract which transfers the right of publicity to the NCAA, or to a manager or agent will sign over all of the rights of publicity or to some third-party corporation and won't be able to get it back. So the only people who can benefit in some respects for the transfer right now are people who are already so powerful that they can't have their rights stripped from them. And so I just want to, when we're thinking about these planning strategies, there's dealing with your individual client, but I also think this is an area, since we're in DC, to highlight some of the potential law reform that needs to take place so that maybe we're helping heirs of celebrities so they're not forced to commodify their identities or have the survivors deal with crass commercialization of their loved one, but we're not taking advantage of every other person.
How exactly do we go about finding out how much your right of publicity is worth? If you're trying to, make these plans, how do you find that out? Is there any
I'll start,
steady-
but then Ms. Royal, I think, will have more to say about how the IRS would value it. I know that, for example, in the Jackson estate, that one of the experts that was brought in for the Jackson estate, which is actually perplexing to me, is a company that specializes in selling celebrity personalities and licensing them. So they had a vested interest in a high valuation, as you can imagine. So that is not the person you want valuing right of publicity if you want it to come in low, a company that makes money by it coming in high. So I just strategy-wise, if you're in that situation, you might want to look elsewhere. But because of who the IRS goes to and others, there are only a very small number of people who could say they're right of publicity value experts. And they largely are these people who have a vested interest in it being high. So that is a whole problem with the valuation process itself. And the valuation is complicated by, and there was an expert filing by a colleague of mine, Eugene Volek, in the Jackson estate saying, well, how do we even value this because of the First Amendment and copyright preemption things? So it's very fuzzy and amorphous, plus the variation in state law. And with that said, I think there are strategies to...
Priya, how does the IRS calculate the value of an estate? And once they do calculate it, what can be done to properly challenge an over-evaluation?
I'm going to mention that and answer that question right after I address some issues that Professor Rothman spoke in terms of IP and planning. But in estate planning, and from an IRS valuation standpoint, you actually want a valuation expert who does these high valuations. Because when you call a valuation company that does right of publicity, the first thing you tell them is not that I need a valuation, but that I need a valuation for estate tax purposes. They will use different comparables. They will use tax beneficial parameters where there is some gray area. And the IRS will give more credibility to those valuations because they know what they're talking about from their perspective, because that is what the IRS has. The IRS has people, and they can outsource to private companies. The very person who values your client's right of publicity in their estate is going to be the same person that the IRS may hire tomorrow on another estate. So wouldn't you want to put apples to apples? And then say my apple is better than yours? That's the idea. So when you asked about IRS, I think I just answered your question. So that's what the methodology is.
With the constant movement of federal estate exemptions, how does a celebrity properly plan and make the adjustments that they have to make with all this movement?
So right now, the estate tax exemption amount is set at 11 million, adjusted for inflation. It's like 11.18, something like that. And it's good until 2026, unless the Brady bill passes, which means that we have it perpetually, or infinitely until Congress changes hands. But so the idea is that when we have tax reform like this, you need an attorney who is abreast of the law changes, who knows how to plan quickly, who knows, because here we have a great opportunity to pass double the amount of assets in valuation out of the estate. You would want your valuation expert to value conservatively, maybe sort of say, at the worst case scenario, this is probably going to be the value, so let's see how much we can pull out of the estate in this amount. So that's, this is where you have to work, and you have to be, most people who have constant rights of publicity, they should be getting updates from their attorneys, they should be getting new law updates, and they should basically be saying, okay, now what for me? And you should be getting a list with a customized plan that says, okay, now we need to change these things.
If the current deduction is $10 or $11 million for a single person, and then that changes in 2026, then does this have to be readjusted again?
Not necessarily. If you're putting it in these vehicles where on paper, the person has given up control on paper, or you're putting it in the grantor retained annuity trust, for example, or an intentionally defective income trust, where basically Mr. Jabbar would get the income that is generated from this commercialization, but he doesn't actually own the name, his control over his name and likeness for estate tax purposes. So essentially, when he dies, it passes out of his estate. It's not in his estate anymore. So you when the exemptions are high, you pull more assets out. So that's sort of...
My last question for you is, so how do you know whose valuation is correct, the IRS's or the valuation company that you hired? And even if it's an apples to apples, how do you plan for an expensive legal battle?
The best way to do that, I usually recommend, with planning, I'm from being tax editor of one of the premier leading tax publications because we address these issues in the portfolios, is that if you have an entirely illiquid estate, which is what you're looking at, rights of publicity are illiquid. There's nothing tangible. There's all intangibles and they're illiquid. You don't want to have to sell Mr. Jabbar's house, for example, to pay taxes. So the classic example that is applied to other wealthy, not necessarily celebrities, even taxpayers, is that you would have a very high amount of life insurance. By the way, the full value of life insurance is also included in the estate, so there's a special trust to pull the life insurance out of the estate and then use the funds from the payout of the life insurance to pay the taxes for the estate. So you do that planning. So that, I think that sort of gives you a general, that's just one of many ideas, but that's one of the more commonly used ones.
Do you give aspirin to people who are trying to figure this out?
Now you know why I apologized. Thank you.
So, we are running out of time. If you have any last questions, we can ask them. Otherwise, I think we need to wrap up because we've got a tight schedule today. Okay, well, thank you. Please give everybody a big round of applause. Thank you.